In this section, I will cover legal terms in land records. I'll not cover every term, but just go through the main ones that you need to know for your examination. It's good to get a good legal term book or manual and study those legal terms and make sure that you understand all of them. First one I'll look at is adverse possession. What is adverse possession? It's gaining title to another land by exercising the rights of ownership of that land unchallenged for a period of time. It depends on the state to the period of time that you might have. But it must be open, notorious, and hostile to the owner of record. Cloud on title. An apparent claim or encumbrance on the title that would restrict the title holder's free use of the land. Such encumbrance may not or may be valid as determined by court action to remove the cloud. Sometimes somebody will put a lien against a house or a property and put an encumbrance on it. You could have taxes that could be an encumbrance. A color of title. A color of title is a deed appearing to convey title, but in fact does not convey title, either because the grantor did not have title to convey, or because the conveyance is flawed in some way. A good example of this might be a quitclaim deed, where somebody quits a claim to a piece of property to another person and they think that they're getting it, but that grantor might not had ownership of that property in order to get that quitclaim. A deed is a document giving the holder the title to property. More generally, any document sealing an agreement or a contract, a bargain, a sale, a quitclaim, and a warranty. You'll also see a warranty deed. This is where somebody will warrant it. You could also see a special warranty deed. For example, if we had a piece of property that we had, a neighbor could quitclaim any that they have over a fence to us or on the other side of a creek to us. What we bought in title, we could warrant when we sell to somebody, but we couldn't warrant what we got under the quitclaim deed. This creates a special warranty deed. A deed of trust is the transfer of property to someone to be held in trust for another. An easement. There's lots of different easements. Let's look at easements. The use of portion of a property for some stated purpose without remuneration. That means that you might be able to own this property's rights, but not the property itself. You could have an ingress or egress, an entrance or exit easement, or a right-of-way easement, or a utility easement. Easements are not estates. They do not convey ownership, but rather the use of the property in so as needed as stated purpose. An example of an easement, a city may have to dig up part of the land to repair the water main. They have the right to use, or they have a contract. This is in contrast to servitude. Now, you can have an easement apparent where you have specific metes and bounds description describing that easement, or you might have an easement that has prescriptive where it's gotten an easement for long use. Now, an easement prescriptive, for it to truly ripen, it must be adjudicated in some form or fashion, that the courts might have to decide that there is an easement here. Just use alone doesn't make it so. Encroachment is to unlawfully or infringe on the property of an owner. A burden or an encumbrance on a property is generally one that affects the ability to transfer the title, such as liens, mortgages, taxes, easements, water rights, etc. Those typically cause you to have some cloud on the title. An estate is a property right held by someone. There can be many estates held on a single piece of property, for example relating to specific uses of the property. The mineral rights, the water rights, and so on are examples of different states that can be held. A grant. The grant is the transfer of title from the government to the first title holder or the piece of property. This term is typically also called a patent. The grantee is the person receiving the grant. The grantor is the person who is issuing the grant. A head right grant. This is pieces of land that were patented or given to immigrants coming to the United States, and head rights were used in other states such as South Carolina, Georgia, also Texas, Virginia. Those had head right grants. Ingress and egress, entering and leaving the land as the means to doing so. A parcel is a piece of land or a tract of land. A patent is the transfer of title from the government, also known as the sovereign, to the first title holder of that piece of land. Also, you'll hear that the word title is a concept that those who had title were able to get patents in the feudal system, and so this is the concept of title being the same as a patent, and also a deed, for example, is the actual document or the process of giving the land from the sovereign or from the landowner to another. Quiet title, illegal proceedings to determine the title of property claimed by multiple parties. If you have two pieces of property that are described that overlap each other, they typically have a trespass to try title issue. When title has been adjudicated to one or the other parties, a quiet title is issued and the determination of who owns it is commenced. A quitclaim deed, it's a common type of deed in which the seller relinquishes the claims to whatever rights they held to a piece of property. Trespass in common law, a suit to recover damage directly made to one's person's property or rights. Again, trespass, and it might be to try title, it's to test the validity of someone's title to that property. A warranty deed, a deed which the seller warrants having a valid title to that property, clear of encumbrance. And a special warranty deed, a warranty deed considered to be to the period during which the seller owned the property. Claims of title defects that predates the title's ownership period are not warranted. Okay, that ends some terms. There's a lot more terms. I would suggest that you get a good law book and study some of these terms.